Your Honor, this is relevant because it shows the possibility of a deer being in the road and therefore the existence of an obstruction upon which the expert has based her report.
What is the hurdle that he has to jump for something to be relevant in the rule? Relevant evidence is evidence that has any tendency, no matter how weak it is, any tendency to show that an issue of material fact is more or less likely to happen. I think this is very weak, but it does have some tendency to show, so it is admissible in my opinion, unless you have some other objection. And there is probably one that I would sustain, but could be then overcome. No?
Our objection was that it was not relevant because the sign is a mile down from the road in which
Still,
and it's a lack of foundation.
yeah, the fact that it's a mile away just further attenuates how weak it is, but it still does have some tendency. That's just something that you guys can address on cross-examination or in closing arguments. Now, your foundation question, what foundation is lacking? She established that that's an accurate representation of the sign that she took a picture of. So what she has established is that on that day, that's a fair and accurate representation. She also needs to establish that that was a fair and accurate representation during the events that took place. I think she read these with Hood. So, that's just something that needs to make sure that, it doesn't matter if, next week there's a sign that says deer crossing. It's what was there when all of this took place. So, your objection is overruled. The picture is admitted.
Thank you. Now, you also stated in your report that Mr. Dawson was traveling down the road at 51 miles per hour. How did you arrive at this conclusion?
I used the combined speed formula.
Can you give us a few details about how you applied the combined speed formula to the case at hand?
Yes, I had to figure out the speed of each section of the collision, and then I had to include drag factor of friction and the distance traveled as well. And I put all these numbers together, and you put them into a formula, and then you take the root of the formula, and that's how you calculate.
Now, what is in your report marked as the speed limit on the road?
45 miles per hour.
Are you aware that Mr. Foster, the investigating officer in the scene, also calculated the speed of the car?
Yes,
Are you aware that your calculations do not match his?
yes, I am aware.
Can you tell us the reason for this discrepancy?
Yes, the officer and I use different drag factors. He used a drag factor of 0.4, and I use a drag factor of 0.1.
Can you tell us what drag factors are?
Drag factor is the amount of friction that is on the road at a given time, as which yields, however, or you plug it into the equation as well to get your final speed.
Yes, Mr. Drum. And the question is, how does the drag factor impact the final calculation of the speed of the vehicle?
A higher drag factor yields a higher speed, and a lower drag factor yields a lower speed.
Did Mr. Foster use a higher drag factor than you did?
Yes, he did.
Do you believe the use of that drag factor to be inappropriate?
Yes, I do.
Why is the use of your drag factor more appropriate than the one used by Officer Foster?
Because the drag factor I used is the one that is necessary when there are extreme slippery conditions, which there were on the night of the 25th.
Do you believe Mr. Foster's report to be valid?
No, I do not.
Now, you also stated in your report and in your statement that the lack of a guardrail caused the car to hit the tree of the utility pole. Can you tell us how you came to this conclusion?
I believe if there had been a guardrail there, the car would not have hit the trees and pole.
Do you believe that it would have made the road safer?
Yes, I do.
In your professional opinion, was there anything Mr. Dawson could have done to avoid this crash?
No, if there was a deer.
Objection, speculation?
Your Honor, she's an expert witness. She's qualified to testify about the physics of the situation that would have resulted in Mr. Dawson not being able to controlled scar if he was trying to avoid such an obstacle.
He asked her to give an opinion, which I think she's qualified to do. I think she's opening the door for you on cross to hammer her when she gives this answer. So think about how, but I will allow it. Repeat your question.
In your professional opinion, is there anything that Mr. Dawson could have done to avoid this crash?
No, I do not.
Thank you, sir. That is all question.
Give me a second. Looks like your teeth captions. Oh, I thought you were. Oh. All right, is there any cross-examination with this witness?
Yes, Your Honor.
All right, go ahead.
Now, Ms. Roman, you were hired by the defense to compile this report, correct?
Yes,
And in this report, you used the calculations found within the Windsor and Strasburg primer, correct?
that's correct.
And this calculation does rely heavily on drag factor, correct?
Yes,
And in this specific drag factor, you used a calculation called vehicle rotating 90 degrees on wet pavement, correct?
yes.
And this factor can fall anywhere between 0.1 and 0.4, correct?
On slippery conditions, yes.
And if the drag factor would have been higher than 0.1, it would have increased the speed, correct?
Yes,
And you calculated that the drag to the car indeed that night was 0.1,
yes,
the lowest possible drag.
yes.
Now, Ms. Roman, can you also tell us what the rest of the formula is called? Isn't it called vehicle rotating,
Objection, compound question.
Let her finish the question, and I think it'll be okay if I see where she's going. But just let her finish the question first.
Ms. Roman, isn't it true that this calculation is completely entitled vehicle rotating 90 degrees on wet pavement with no brakes?
Yes, I would believe so.
And if brakes were applied, would this not increase the drag factor?
No, I do believe that they would not.
So you're saying that this would not affect the drag factor?
If he used brakes, or, I'm sorry, could you restate the question?
If the defendant would have used the brakes, would this have affected the drag factor?
Objection, Your Honor, asked and answered.
Well, it hadn't been answered yet.
She answered no.
And she actually asked for her to repeat the question.
But
So,
before that, she answered no to the previous question.
overruled. You can re-ask the question, or the witness can answer it.
No, the brakes and the drag factor are two different things. The drag factor is just the friction on the road.
And by applying the brakes, would this not increase the friction of the road?
I believe yes, it would.
So this would indeed increase the drag factor,
Yes, it would.
which would increase the speed.
Yes,
Now, Mr. Roman, you also say that the defendant hit both a tree and a power pole, correct?
yes,
And according to the Windsor and Strasburg report, the combined speed formula also takes into the depth of the collisions on both the front and side of the vehicle, correct?
that's correct.
And a narrow object is any object that is less than 2 feet across, correct?
Yes,
And the utility pole was indeed less than 2 feet across, correct?
yes,
And so for the impact, you did use a different equation which called for a narrow impact.
yes.
Ms. Roman, how wide was the tree that the car impacted?
2 feet.
How wide was the tree that the car impacted?
I'm sorry, I can't recall right now.
Ms. Roman, do you remember giving your sworn testimony today?
Yes, I do.
Permission to approach witness after posting for the court.
This shouldn't be an impeachment, yes, or call, Your Honor.
Whatever the attorney wants to do is her cross. But let's use this as a constructive timeout real quick. This would be a good opportunity to refresh the witness's memory, not necessarily impeach them with their affidavit. And I don't know if that's what you're gonna do, but ask your team captain about it later. Go ahead.
No, Ms. Roman. In this exhibit, it's a photograph that you took, in which it states that the tree that the defendant struck was 39 inches across, correct?
Yes, that's correct.
Which is greater than 2 feet.
Yes,
And in your report, you stated that the defendant hit a pole and a tree, correct? In your report, you did not state which the defendant hit first, correct?
no, I did not.
So, if the defendant were to have hit the tree first, your findings would have been correct?
Yes.
So your findings would have been incorrect if the defendant had hit the tree first.
Yes, I suppose that's true.
Now, Ms. Roman, you were hired by the defense to specifically analyze the possibility that a deer was the cause of this wreck, correct?
Yes, I was.
And you found that there is a possibility that the defendant did swerve to avoid a deer.
Yes, that's true.
You actually stated that the defendant could have swerved to avoid any sudden appearing obstacle, correct?
Yes.
But you cannot conclusively state that this is what caused the wreck.
No, I cannot say that a deer jumped out the road.
You can only state that the defendant did indeed swerve off the right side of the road and then overcorrect, causing the
Yes.
collision.
Yes, but I can also say that when I've dealt with cases like this before, his swerving is consistent with drivers swerving to avoid an object in the road.
But you can only conclusively state that he did indeed swerve off the side of the road,
Yes,
correct?
that's correct.
No further questions, Your Honor.
Redirect.
Yes, Your Honor, I'll redirect. Mrs. Roman, just to be clear, were the marks made by the vehicle swerving off the road indicative of the vehicle trying to avoid an obstacle, such as a deer?
Yes, I believe that they were.
And just to clarify, you found no evidence suggesting that deer were not present.
Yes, it's true.
And in fact, you found a sign alongside the road that indicated that deer were often present alongside the road.
That's correct, yes.
Thank you. That is all.
Ms. Roman, opposing counsel asked you if there was anything Danny Roman could have done to avoid that accident, and you said no. Is that correct?
Yes.
Now, you would agree that drinking, no matter at what level, slows your reaction time.
Yes, I'm no authority on alcohol though, so.
But you would agree that it does slow your reaction
Yeah.
time.
Objection, Your Honor. This is outside the expert's scope of knowledge.
You would agree that,
Who's it gonna answer to?
you would agree
Overruled.
that, that not only does it slow your reaction time, that it does in some ways affect your ability to operate a motor vehicle,
I would assume so, yes.
to operate machinery.
Yes.
That's why there are all those warnings on everything, right?
Objection, Your Honor. Outside scope.
So, are you aware through your investigation that the defendant had been drinking that night?
I was made aware of it after my investigation.
So, once again,
Or,
after considering that the defendant had been drinking that night, that drinking does slow your reaction time, that drinking does do this, that does do that, is there anything Danny thought, isn't it true that if he wouldn't have been drinking, that might have impacted it? Those are the kinds of questions that I thought that you might hit on. When he asked a question like, is there anything that he could have done? Hell yeah, he could have been sober. So that's a dangerous question to end on, because that would have been my very first question, getting back up there. Other than that, it was a good direct and a good cross both ways. You'll learn this more and more. The part about whether or not applying the brakes, I don't know if this contradicts with what's in your affidavit, but you could have said no. He was already spinning. His wheels had already lost, traction, and applying the brakes would have done nothing. And if there's not something in there that says otherwise, she has to live with that answer. Okay? So, that would be one way you could address that issue. The business record exception, you covered it, and then covered it some more, and then 3 more questions were added on that after. There are like 4 or 5 things that you have to establish. Go through and name those 4 or 5 things, and then, don't overdo it, because I kept waiting. I was like, all right, I want to get to the meat of it, not keep hearing all these foundational questions. And if they object, then you can always go back and establish more. It's not like you're cut off. Anything else?
Zuzi, doing better. Still need to speak up a little bit. Very good job as an expert. Say pre-mark for identification, R10. You could object to the Shelby, you could object to conclusions in the report if you don't think that they've laid the foundation, because there are conclusions in the report. So just because you think it's not hearsay, you can still object to items that are in the report, like say the conclusion that it's consistent with a deer. They hadn't laid the foundation for the methodology and everything. And to get in that opinion yet, since that opinion is in the report, you can pick out a piece of that report and object to it. And say, Your Honor, my objection is the foundation's not been laid for opinions within the report to be given. Have you heard on that? Your Honor, within the report, there are these opinions that X, Y, and Z, and I believe the foundation's not been laid for that yet. Tim, you have a very good courtroom presence, I think, but you have the tendency to talk with your hands a lot. Try not to do it so much, or maybe just do it with one hand or something like that. It can get distracting when you're doing it after every question.
Or do it on the important stuff, but not every question.
Yeah. On cross-examination, when you're talking about technical issues, and for everybody, talk about technical issues for witnesses and for attorneys, I would slow down. Because the jury, I mean, you guys read the case, you guys kind of know the facts, but the jury or your judges, your amateur judges, are not going to know about it. So if you slow it down a little bit, they're going to be more likely to get it. Tim, don't argue with the judge. You're still arguing with the judge, see?
No, I was asking you for something.
You got kind of back and forth with the judge, don't ever do that. Improper refresh of memory. If you've got a witness that, I prefer impeaching a witness, but if the witness is just saying, I can't remember.
Yeah, not if they're not lying.
Yeah, if they're saying, you cannot remember, doctor, you cannot remember, sorry, Mrs. Rowan, you're not a doctor. Okay, it looked like a doctor. Ms. Roman, you don't remember what's in your own report? Is that your testimony? Okay. Grab her, and I'm taking somebody's sheet. You show opposing counsel, I'm showing opposing counsel what's been pre-marked for identification as defense exhibit A, may approach the witness. Showing the witness what's been pre-marked for identification as state's exhibit A. If you would take a look at lines 3 and 4, read over it silently and let me know when you're done. Reads over, like that was done. Now, does that refresh your memory as to whatever the
How wide the tree was.
How wide the tree was. And she says, yes, okay, if I may. How wide was the tree? And you gotta take the report back from the witness before you ask him that question, because we know the witness just read it and is gonna repeat what she read, but technically the rule contemplates it. You can read it and say, well, I know that's what it says, but I don't remember it. So you don't want the witness to be reading from the report. You want the witness memory to actually get refreshed. Take it back and ask the question again. That's all I have for that witness, I think. Tim, careful not to lead and redirect. A lot of attorneys do that. They fall into the habit of leading once they get up to redirect. And the judge will give you a little bit more latitude on redirect with the did questions and things like that usually. But I mean, you were just asking straight up statements and just having the witness answer like on a cross. So be careful. That's it.
Zuzia, one way to maybe start with kind of developing a persona for this expert, you definitely fit the demeanor for it, but it may even seem like it's out of your comfort zone, but one way to just really, really score high as an expert is to sound absolutely enthralled with the science and the findings behind your research and stuff like that. I mean, it'll seem weird, like, to articulate it in such a way, like, well, you know.
Yeah, don't try to talk like her, but think about Abby on NCIS, how, she just gets off on the science behind it.
Yeah.
It excites her,
Right.
And so, you want to share your love of this with everybody, because they're going to be just as excited as you are.
Chances are they're not going to think you're coming off as like a huge dork and you're like way too into this stuff. They're going to, I mean, what it's going to do is it's going to help the delivery be a lot more compelling. And that's really what you want, stupid people like attorneys who are judging you and law students to think like, oh my God, this is really fascinating stuff. This is really clear to me what she's doing. So that might be a good place to start. We can work on it at some point. That's everything I've got for the director is basically said, except one thing. Tim, when you were arguing your objections, and I love that you got confidence when you're arguing objections. I think that's very important because you'll get by with stuff that you really shouldn't get by with. But be careful because you, direct, it wasn't as bad, but on cross you kind of stepped into, sounded like you're arguing with the judge. And it's all in how the tone is. When you kind of sound like you're impatient with the other attorney or something, you don't want to go that far with it, but you definitely want to sound confident when you're arguing your objections, and you did that. And yeah, you talked about the hand thing. Yeah, watch. I've got my own things too. I'm doing it right now for God's sake. But that's all I got for it. That's all three witnesses, isn't it? It's closing.
All right, is that it for the defense case in chief?
Yes.
Are you ready for closings?
Defense is ready.
You don't want 5 minute break?
Your Honor, the prosecution is ready for close, but we would request a cigarette break.
All right.
Everyone has to have 6.
5:22. We're going to take an 8-minute break. Everybody be back and ready at 5:30. So we can be done by 5:55.